begin by talking about how the courts are a little bit different from the other institutions of government as a policy-making institution. Much of what I'm going to say here applies to the federal courts generally, but I want to focus specifically on the aspects of these particulars as they relate to the Supreme Court of the United States. Okay, so let's begin by talking about the fact that unlike Congress, or unlike the president, or even unlike the bureaucracies that can go out and actively identify some problem, social problem or economic problem, and resolve to undertake that issue and try to come up with some solution to that problem, the courts are passive actors. Right? The Supreme Court of the United States, unlike Congress, unlike the president, unlike the bureaucracies, cannot go out and identify social problems and say, we want to fix this problem. Okay? Like, say, the president can say, I want to fix the immigration problem. Or Congress can say, we want to fix the health care problem. Right? The courts, the United States Supreme Court, has to wait for these problems to come to it in the form of litigation. Right? That's what I mean when I say, if you get too busy trying to copy down stuff off the screen, we're going to get to the stuff on the screen. Maybe you do, maybe you don't. Okay, just depending on time. But if you get too busy copying stuff down on the screen, you're going to miss the context of what we're talking about right now. Okay, so if you want to divide your attention, that's fine, but don't get too occupied with what's up there on the screen. Okay. For example, what I just said.
The courts are passive actors in that they can't directly, what's the word for it? Well, the president can actively seek out an issue, but the courts can't.
They have to wait for the problems to come to them in the form of litigation, right? In the form of lawsuits. Not good. Now, it's important, particularly when we're talking about the United States Supreme Court, to talk about the difference in the two different types of jurisdiction. Okay? So you can see up there on the screen, I've indicated that when we're talking about the Supreme Court, we distinguish between the original jurisdiction and the appellate jurisdiction of the court. And notice that only 5% of the caseload of the United States Supreme Court in a given session fall under its original jurisdiction, and the 95% of the caseload falls under its appellate jurisdiction. So that means, for the most part, the Supreme Court functions as an appellate court. Okay? What do we mean by a court of original jurisdiction? Well, most simply, what we mean by that is the court to hear a case first. Okay? So a court of original jurisdiction functions as a trial court. Right? And it is deciding questions, mainly deciding questions of fact. What are the facts in this case? And then reconciling the facts with the existing law. Okay? That's what a trial court does. Court of original jurisdiction functions as a trial court, and it's dealing with questions, mainly questions of fact, and the application of those facts to the law, or probably more accurately, the application of the law to those facts. Okay? It is important to note, when talking about the Supreme Court of the United States, that the original jurisdiction of the Supreme Court is set by the Constitution. Okay? That's a very critical point. Okay? Even though the caseload, only about 5% of the caseload falls under its original jurisdiction, it's important to note that the original jurisdiction is set by the Constitution, and the Constitution indicates that the original jurisdiction of the Supreme Court it extends to all cases affecting ambassadors, other public ministers, and consuls, and in cases in which a state is a party. Now, that doesn't mean that the Supreme Court will exercise original jurisdiction if you have a case in which a state is a party, because the Supreme Court shares original jurisdiction with other courts as well, but it may. The Constitution then indicates that the appellate jurisdiction of the Supreme Court extends to all other cases arising under the judicial power of the United States. The Supreme Court has appellate jurisdiction, that is the power to review decisions of other courts, except in instances in which Congress determines otherwise. And there have been, from time to time, instances where Congress has passed legislation defining the appellate jurisdiction of the Supreme Court, but it has historically done so mainly in an effort to help the court manage the appellate court's caseload. Right? What it really ultimately means is that the Supreme Court of the United States can exercise appellate jurisdiction basically over any case arising under